Good afternoon, Kentucky Realtor family. I certainly hope that each of you and your families are doing well. Realtors across the state continue to be busy. Several contributing factors include the pent-up demand for homes, for those who wanted to move, but the limited inventory has slowed that process for them. Also a high demand for to move into new homes, and then the fantastic interest rates that we have. All these factors often contribute and lead to multiple offer situations. And as realtors, we're always looking to make sure that we do all that we can to help our clients secure the home of their dreams. In this highly competitive market, what's the best way to provide the service to your clients without bending or breaking the rules? Rules that could ultimately land you in hot water with possibly an ethics violation or complaint filed against you. Yes, we want to do all that we can for our clients, and unfortunately, it simply may not be enough at times. Losing out on several offers can be frustrating, both for you as well as your clients. And you must always remember that as a realtor, you simply cannot cross that line because of your ignorance, because when you do, it turns into a bad behavior on your part. Remember, first of all, this is Ethics Week, and across NAR and our association, we're taking ethics classes, particularly in Kentucky with Lee Brown today. One of the things that we boast proudly that separates us from other agents that are not realtors is our 107-year-old code of ethics and respecting the realtor golden rule. Yes, you're a presidential appointed group, and also we reached out to our CEO, Steve Stevens, and had him reach out to the AEs for ideas and both for this conversation. And both groups came back with the same thing, making sure that our members are reminded of our code of ethics and standards of practice. The code reminds us that we have duties to the client, duties to the public, and duties to our fellow realtors. So with us today to present professionalism, competitiveness, and the COVID-19, we have Rene Garcia, we have Charlie Lee, and Rodney Gansho. Thanks to each of you for being here, and Julie Johnson for reaching out to make sure that you were able to be with us today. With that, I turn it over to our moderator, NAR Director Lamont Breland, and thank you so much.
Thank you, Lester. Thank you for all you're doing during these difficult and challenging times for our association. Well, gentlemen, welcome to our town hall. We appreciate having you all here. As Lester said, you know, I look at our market here in Louisville, where I'm out of. We've got about 5,000 realtors, and we've got 1,800, little over 1,800 actives, and about 3,100 pendings or active under contract. So that creates a little bit of angst we can do the math, right? So that sometimes that can create some situations where maybe agents feel pressured to do things that maybe they know better, or maybe they don't. So for me, it always goes back to the golden rule, doing to others as you would have others doing to you, which is built into our code of ethics. But specifically in Article 12, it does talk about honest and truthful communication to the public and to our fellow agents. So can you all talk a little bit maybe about what you're seeing across the country as it relates to this?
Lamont, thanks so much for the intro, and really thank you all for giving Rene, Charlie, and myself the opportunity to meet with you. We're in lockdown just like I assume most of you, if not all of you. NAR's offices have been closed since March, so we're all working out of our homes. And it's great to have the interaction with you, if only remotely. Lots of stuff taking place in real estate, lots of stuff taking place, period, right? Inventory has been low for years. A lot of different business practices have been emerging because of that. We have the new clear cooperation policy that went into place earlier this year to try and address some different concerns. And I love, I didn't know you guys had a Ethics Week. We don't have that on a national level. I got to tell you, I love that idea. We might want to float that with some of the people at NAR to see if that's something we could push for. Diane Mosley's on this call as well. She's involved in our training and our PS side. And I think it's just a great way to approach stuff because right, we need to focus on ethics and the membership need to focus on ethics. It is a challenging time. It was challenging before the pandemic, and the pandemic brings it to a whole different level, from low inventory to the heightened level of competition among our members. And where in doubt, we should all advise and they should all lean on the ethical principles that are established in the Code of Ethics. Not just Article 12. Article 12 talks about creating a true picture in your representations and advertisements to the public, which is just a cornerstone of what they do, but also Article 1, right? Never overlook Article 1 and emphasize the ethical duties established in Article 1 to act in your client's best interest. Because what we're seeing at a national level is there's some members out there, and some of it might be unintentional, some of it's just that heightened level of competition where they're doing things that I don't think they would normally do, but it's the environment that we're in that is questionable whether that's in their client's best interest or in their own interest to try and either get a listing or create some competitive advantage with the other brokers in a marketplace. So from my standpoint, and I'll turn it over to Charlie and Rene to add to it, but from my standpoint, those are the two key principles that we should be promoting to our members and that members should be leaning on, is to always be acting in their client's best interest. I have that foremost on their minds. And when they're talking about representations and communications with the public, that they should be creating a true picture, no misrepresentation, no misleading advertising, things like that. And I'll stop there. I'll turn it over to Charlie and Rene to add anything more.
And Rodney,
Yeah.
before you guys go on, I don't know if we mentioned your all's titles. Rodney,
Okay.
you're Director of Engagement with NAR, and Rene, you're Director of MLS Engagement. So I guess you all work very closely together. What exactly do you guys do in that role?
Oh, thanks, Lamont. And that is important, right? Who are these guys talking to you from National? Should we be listening to them in the first place? So we're part of NAR's MLS team. Rene is our Director of Engagement on MLS. He's the one reaching out to different MLS's industries, or not industries, but companies and different entities related to MLS. Charlie is our legal affairs support for anything that we do. He makes sure that Rene and myself stay out of trouble and NAR stays out of trouble. Myself, I am the staff executive for NAR's MLS Issues and Policies Committee. And I also staff the NAR MLS Advisory Board. Those two groups, when you talk about clear cooperation, that's where that policy came out of. The Advisory Board is a subset of the committee, meets usually a month and a half in advance of the national meetings, and they kind of get lost in the weeds on different policy initiatives. It's a smaller group, about 20 people. The NAR committee is about 120. I'll let Rene and Charlie, with any comments they share about Lamont's first point, to add anything they want to with regard to their positions at NAR.
Absolutely. Gentlemen?
Yeah, thank you for that. And I just echo what Rodney said. It really is a great privilege when we're able to just get in front of members and have this opportunity, especially just during this challenging time that we're going through. So I'm just thankful for this chance. And for myself, I consider myself the third wheel of this MLS team. I'm the guy that rides Rodney and Rene's coattails, and I'm also the wet blanket. I tell them no often, and I like to make their lives a little bit more difficult by challenging just their thoughts about certain things. But all in all, we are looking out for our members' interests and just trying to ensure that we provide proper guidance and the best resources available. Just a quick thing to add on to what Rodney said. I think the guiding principle really is fulfilling the code of ethics and looking to serve the best interests of your client. And as we're going through uncharted territory where we're having to deal more with technology, and we have low inventory and there's just a lot of competition, I think our membership numbers have actually grown, which was just, it's crazy to think about given how scary things were. And so we're very fortunate that our industry is doing well. But at the same time, I think, we're becoming very creative and we're trying out new things. And, the thing that I think people just need to be sure that they're doing, and that is dictating how they're making those decisions, is just whether it is actually serving the best interests of their client, and that they're dotting their I's and crossing their T's. This means, signing the agreement, having those necessary discussions in talking about, how you're going to serve your client's interest, talking to them about, the pros and cons about different marketing strategies, and then just letting them know, what you are doing as their authorized representative. And remembering that where that authority comes from is from that listing agreement or that representation agreement. So, and then also just in terms of staying away from any sort of advertising or marketing that could be considered deceptive, false, or misleading. So I'll turn it over to Rene.
Thank you, Charlie. And again, I'll echo, thank you, Lester, Lamont, and Steve, and all of you for welcoming us into your meeting. I appreciate the opportunity. So, my background, I come to NAR by way of California Regional MLS, where I worked for a number of years at the MLS there and ran their compliance and data licensing department. So, this is right, squarely right with what we dealt with day in and day out. And certainly at that time, Article 12 and presenting true picture and the rules behind that had a broad focus, and it still does. But I think what's been amplified as a result of the pandemic, the stay-at-home orders, and how business has evolved over the last several months, is a hyper focus on what everyone's doing, with technology, what you're presenting online, and it doesn't. We can certainly touch on the other areas as well, but that's certainly the main concern that we've seen, at least that I've seen recently, and ensuring that folks are sharing and communicating the right information to consumers and to other members. I love that Lester started off with the golden rule, and gosh, if we could stick to that informs everything else that we do, right? That kind of guides the code of ethics, and if we stuck to that principle, that would address most of the issues. And we may explore this a little further, but as an example of some of the issues or some of the concerns that have come up, related to the MLS side of things and how information is being presented out, is because consumers are spending more time, oftentimes they're only able to see real estate by sitting in front of a computer. It certainly becomes much more important to ensure that in the quest to provide more information to them, that it's actually framing and providing the right information, the accurate information, and is it misleading them? And it could be anything from representing the correct and accurate days on market of a property, to photo manipulation, ensuring that if you do have professional photographers going out, that they're not editing the photos to give the wrong impression or mislead consumers, intentionally or not, right? Things like misplacing where the sun is rising or setting. We've had questions about that, and whether or not there's actually a particular view from a property because of the editing of the photograph. But so those are some of the questions that we're getting and some of the issues that we're dealing with as a result of our current environment as it relates to true picture.
Very good, very good. So you mentioned that I had thought about the picture. I remember once a couple of years ago, I think someone on Good Morning America or something they were showing this emerging technology, and they were actually changing, the view out the back window, to like mountains. Obviously that would be kind of an explicit violation. What are some examples of things that maybe some of our agents or realtors across the country might be doing that maybe it's more, I guess, implicit? They're not trying to be deceptive, but they're maybe just over the line, which could create a situation for maybe an ethics violation. Anything come to mind?
Yeah, just to continue the discussion on photographs, right? And we have to ensure that while members follow the code of ethics and MLS rules, sometimes the service providers aren't well versed in exactly the nuance, right? As an example, one issue comes to mind that I dealt with at the MLS where a listing broker had a professional photographer go out who in turn, took some great photographs, but took some liberties on editing the photographs from a photographer's standpoint, right? Which is understandable. They touched up the grass, added in a planter, and they erased an overhead power line that was dropping down to a property. And that comes up regularly. I think I may have seen one recently that way. And the member didn't catch that. They certainly, it wasn't intentional. They weren't trying to deceive anyone. They contracted with a service provider. They got the photographs back. They got uploaded, and they were, going about the business of selling the home. So that's one example of kind of the overlap when, the duties, the membership duties, and the code of ethics and MLS rules, working with other service providers. I mentioned the days on market issue, and we saw this with the implementation of the clear cooperation policy. The clear cooperation policy, as you know, isn't a coming soon policy. It doesn't require coming soon, doesn't prohibit it, but many MLSs locally in their implementation adopted a coming soon status to go with that. So in those implementations, or even the accommodating or changes to active status with a delayed showing or no available showing, and it's in the way that coming soon is being, the days on market is being handled with those statuses where in some areas, there's no accumulation of days on market, and it's being presented to a homeowner as, or a potential purchaser rather, as, hey, this property's been on the market for 0 days, but it's actually been in status and shared widely and marketed for 30, 60, 90 days. And while we don't have a national policy addressing days on market, that is something that members should consider in how they frame or position property information to consumers, relate to photographs and days on market. So those are the two common examples that come to mind. Rodney, do you have some others that you would add?
I'm going to hit the one right on the head, man. And it's the basis of the clear cooperation policy that if listing brokers are exempting the listing from the MLS, if they are not sharing the listing with other brokers in the marketplace, they should be talking with their clients. They should be figuring out what the interests are of that client and making sure that the marketing strategy that they employ with the seller is one that suits their needs and interests. It is widely established and understood that wide distribution of a listing, like through the MLS to verified other practitioners in the area who are working with bona fide purchasers, that they are likely going to bring forward the most favorable purchasing terms and the highest purchasing price. Just because you can get the seller to sign a waiver to keep it out of the MLS doesn't necessarily mean that that's acting in your seller's best interest. Make sure that you explain the pros and cons of keeping the listing on the MLS or off the MLS. And from the clear cooperation policy, if you all likely know, what it determined is if you're keeping it off the MLS, but then you are publicly marketing that property. Publicly marketing means putting a sign in the yard, putting it on the internet, even sharing it with other brokerage firms and agents who may have a seller or a client that could be interested in it, that constitutes exposing it to the marketplace. And if you're exposing it to a portion of the marketplace, it should be in your client's best interest to expose it to the entire marketplace. And clear cooperation compels brokers to put it in the MLS so that it gets that wider distribution. So that's the one that I would stress the most, and it's the one that's the most challenging right now. And the reason why you have the clear cooperation policy, and you're going to hear it throughout the comments from Charlie, Rene, and myself. It's the heightened competition. It's the low inventory that drives some of these actions that otherwise may not be taken. So I would say if you're exempting a listing from the MLS, make sure that you're discussing the pros and cons of the MLS and that you're acting in your client's best interest.
And Rodney, to clarify, is it true that the property has to be listed in an MLS within 2 business days?
So what clear cooperation calls for is 1 business day, actually.
1 business day.
That if from when it's publicly marketed. So if in talking with your client, you've determined that there are some privacy issues or something that calls for the listing to not be put in the multiple listing service, And at some point along the way, that property does get public marketing, that the listing broker would have 1 business day to then file that listing with the MLS.
So if someone was looking for an angle to still kind of be on the line, it seems like maybe some are listing properties on or marketing them on Friday, but then not maybe putting them in the MLS till Monday. Would that be a violation?
So that wouldn't be a violation of clear cooperation, but then you got to look to your own MLS rules and regulations for your filing deadline. Because clear cooperation, it has a specific intent, and the intent is where it's kept out of the MLS. It's not in the MLS yet. Other brokers are unaware of it yet.
Okay.
That if you have public marketing, you have to file it with the MLS within 1 business day. In addition to that, your own MLS rules and regulations in the NAR model, it's section 1, has a time frame when you get the contract signed by the seller, and it's a valid listing agreement, that you have a certain time frame to file it with the MLS. In the NAR model, it's blank, so it's determined locally. I don't know if you know off the top of your head what the filing deadline is. I'm sure some of you likely do. But that time frame and that filing deadline is still applicable.
Okay. In Kentucky, we've got 21 different associations, so I guess they could be different depending on associations. Is that correct?
That is correct, yes.
Okay. So do you see any, I guess this has been in effect for 3 months, 4 months? How long has it been in effect?
So it was adopted by the NAR Board of Directors in November of 2019. Some MLSs implemented it shortly thereafter. All MLSs that are Realtor Association owned and operated have to have adopted the clear cooperation policy and implemented it by May 1 of 2020.
And you all see, anytime you change a policy, anytime you do anything different, sometimes we have to work out the wrinkles. Are there any things you see on the horizon that are obviously probably in need of change, or nothing yet?
I can say there are questions with regard to implementation and interpretation, but the intent behind the policy, which is to get more listings in the MLS so brokers are aware of it. And the example we like to share is there was a member of one of our MLS teams that shared an example of how he was showing, and they're practitioners, by the way. These aren't made up by staff. These are made up of practitioners and MLS executives from across the country. And he was showing a property in a particular area, and the client pointed out that there was a property that they didn't have on their list of showings for that day that had a for sale sign out in front of it as they drove past. Brokers shouldn't be surprised by properties that are in the marketplace. They should be able to learn about those through the MLS. I forget where I was. It needed to be adopted by May 1 of 2020.
Okay, all right. And Charlie, do you see any, what I guess would be the penalty for someone who, and maybe this is outside of your area, but for someone who would repeatedly maybe push this to the limit, because I know it makes a lot, what it does, it makes, not only does it appear to be bad for your client, but it makes your fellow realtors, puts them in a very bad position when their clients see it. It's not in the MLS. They finally try to get the appointment on Monday and it's sold. And it makes us look bad as professionals. And it just appears to be very unprofessional. What would be the, I guess, the penalties for repeated abuses of that?
Well, so I think there's different ways that this could all play out, and I'll try to touch as many of them as I can. One is with the clear cooperation policy, then you're going to be subject to enforcement by the MLS. And then the other part is that you have licensing laws. I don't know what it is in Kentucky, but I know that in certain states, there were concerns about the use of pocket listings and coming soons and the way that they were misleading to consumers. And so your licensing commission or the licensing board could have something to say about your actions, especially if it's reported. The other is that you could be subject to a lawsuit. When I've given a presentation about pocket listings, there is a recent case that's involves some a practitioner who is fairly famous, and he got sued because he used a pocket listing. And in the in the litigation, the question came up whether he had the authority to market it as a pocket listing, and he asserted that he did, but he didn't have the documentation to prove that. And so as a result, the seller here was suing the broker for breach of fiduciary duties, because what happened was that that home then got flipped and sold for more than double of what he sold it for initially. And so those are the things that can definitely happen, and that brokers need to be beware of if they're going to use an office exclusive or a pocket listing marketing tactic.
Are there any arguments that you've heard that are good for why would an agent ever, why would a client ever agree to allow their property to be not marketed, you know, in our market to 5,000 agents, as opposed to just a few? What are there some scenarios where that's a good idea?
Yeah, so, you know, I would say just on its face, it kind of belies just your natural instinct and, you know, just logic in terms of when you're looking to sell your property or sell your asset, you're probably looking to get the highest and best price for it. But, you know, we understand that, you know, there are clients who are celebrities or who just need to maintain a certain level of privacy and may not be comfortable in having, you know, strange people coming through their house. And that's where the onus is really on the broker to have that discussion with their client to understand what exactly they're forfeiting when they decide to not list it on the MLS, to not have that broad marketing exposure, because they are then risking losing out on the opportunities of getting more for their property.
That makes sense. All right, let's talk about the four-letter word teams. Okay, okay, it's 5. But you know, that is the emerging model, or has been for a few years now. And I know in Kentucky it has become an issue. And you know, our governing body in the Kentucky Real Estate Commission has taken a position about advertising team names. You know, many times I know in our state, you'll see a team name is this big, and then the brokerage name is that big. And now we've made a change where the brokerage name the team name cannot appear larger than the brokerage name. Would that fall under the Article 12 of the Code of Ethics? In other words, is that misleading advertising if the brokerage name is very small as opposed to the team name?
So Rodney, go ahead.
Yeah, go ahead.
Take it, or you can take it.
I was going to provide an MLS answer to give you time to prep the Code of Ethics answer.
I got it. So see, we work well together, don't we? It is an ethics issue. In fact, the NAR Professional Standards Committee, and they have a subset to it, Interpretations and Procedures Subcommittee. They looked at this a number of years ago. Let me look at the date. Actually, 4 years ago, they amended. And it's Standard of Practice 12.5. Standard of Practice 12.5 in the NAR Code of Ethics. So the article of the code is the ethical duty. That's that high standard that all realtors need to abide by. The SOPs, and there's a number of them underneath the article, help to amplify and interpret that article. So what 12.5 talks about is when you're advertising, and the article says you got to be true picture in your advertisements. The SOP helps to explain that by saying that would include the requirements. So any advertising that's done by a realtor has to include a connection to their real estate brokerage firm. So with a team, if they're advertising a team or a certain property in connection with that team, they would still, under the Article 12 of the Code of Ethics, need to identify the listing firm.
Gotcha. And SOP is standard of practice, correct?
Standard of practice, correct.
Okay. Anybody else want to add on to that?
Yeah, I was just going to add that from the MLS rules perspective, right? You may have local MLS rules addressing this, especially for MLSs and you know, parts of various states where non-realtor members can join the MLS. You might see some overlap there on the MLS rules, but this also reaches things like IDX display, you know, not just, you know, hard copy flyers or printouts or static web display. So what Rodney touched on would certainly would be a consideration. When I was at the MLS, though, another area that you may want to have in the back of your mind is the state licensed law enforcement. In California, the state commissioner there implemented some fairly strict regulations addressing advertising of team names, and their enforcement posture was fairly aggressive. And they're not looking at it from the perspective of what the intent was, or was this an oversight or mistake. They were fairly, you either did or you didn't, and here's either your citation or we're filing charges against you, whatever the case may be. So I bring that up just to say that it's important to not only have code of ethics consideration, MLS rules consideration, and maybe the enforcement process at the MLS level to help address some of these concerns and keep members out of trouble, but also bring in licensed law officials into the conversation if you're not already doing so. Charlie Lee is a liaison for RELO, the Association of Real Estate Licensed Law Officials. And so we have that connection there, and I'll turn it over to Charlie in just a second, see if he has any thoughts. But auditing what everyone is doing within the brokerage, triggers brokerage supervision issues as well. So it's not just the advertising party who may be running afoul of code of ethics. They certainly want to think about it from the brokerage perspective, qualifying broker, managing broker, essentially the responsible party, right, for their licensees, and ensuring that they're following not only code of ethics, MLS rules, license laws, but also office policy, which may oftentimes steer folks in the right direction. Charlie?
Yeah, thanks for that, Rene. And I am the liaison to ARELO, which is the Association for State Real Estate Commissions. And what I'll tell you is that at their one of their major meetings that happened last year, I sat in on a group discussion amongst these real estate commissioners, and a lot of them expressed concern and frustration about just not being able to discern, who to contact, and how it was very unclear from the advertisement about who the managing broker was, and if there were any issues, even from the enforcement side, who they were able to contact. And so there was just this sentiment that they wanted, like Rene was saying, what happened in California, that they wanted laws to allow them to regulate this better, to require teams to make it more clear and to put it up front who it is that consumers can contact, who the government can contact if there are any issues with regards to any property or any of the things that the teams are engaging in.
I wanted to add just one thing to my comments. I made the statement that in advertising listed property that they would have to disclose the listing firm. Actually, any listed property or any services of a brokerage. So if a team is advertising their services, they would have to disclose the name of their brokerage firm as part of that advertisement. Otherwise, that's a potential violation of Article 12.
Gotcha. Anything else on Article 12? If not, let me know. I'm going to switch over to antitrust. Anything else that we're missing? We can always come back to it. Let's talk about antitrust for a minute. NAR came out with it's about a 14-minute video, Antitrust 101, which is a download that I know a lot of associations are pushing out to their membership. I mentioned it before the call. Antitrust to me is I've always seen it as a group of people, as you all started out in the video, just a group of brokers saying, we need to get our commissions up. I'm going up to this price. You all should follow suit. Well, that's pretty blatant. That apparently that happened in 1970 or something like that. But what are some of the more subtle antitrust issues that you see that may be arising that are kind of putting the antitrust issue to the forefront right now?
So yes, the subtle thing. So I think with antitrust, what you have to remember is that while there's the side of reality, and this is where people will say, that was not my intent. I did not intend to conspire with Lamont to raise my commission rates or to maybe boycott against someone. But then there's the side of perception. And perception is what outsiders see. If you go into the court of law and you have, you know, a plaintiff's attorney who is going to argue that there was a conspiracy, then you have to be able to refute that. And so that's why we implore brokers, realtors to be very cautious when it comes to any sort of discussions about commission rates or any sort of tactics to adopt practice or standard, because then that can be viewed as being a contract or a trust, an agreement amongst competitors, or a conspiracy. The ways that these things can happen is just, you know, if you have a standard form and, like, let's say the commission rate reflects that what you've seen that others are charging, and you think that, well, I am only following the trend, but then what you do is that in a way that can be viewed as being a conspiracy, because now you are saying that this is what all the other competitors are charging, and therefore I am participating in that conspiracy. And that's why we say that should be a blank field. That's something that you need to discuss with your client, make sure that that is negotiated, and they understand why it is that that commission rate is the commission rate that you've agreed upon. The other is in terms of, you know, when you are making any sort of announcements or like in the listing fields, if you're going to list your commission rate, it should be made unilaterally, meaning that it's independent of what everyone else is doing, and it is serving the interest of your client, and it's for a business interest, not because you are looking to somehow get everybody else to charge the same commission rate in order to entice cooperation. The other is that you don't want to make any comments that this is the standard rate, or that, you know, this is the rate that I need to charge because I know so-and-so or most of the brokers are not going to bring buyers to look at your house as a result. No. All of these things really had to, I think the guiding principle here is that you have to treat these things independently, and you have to treat them one-on-one, so meaning unilaterally, absent what everyone else is doing. And if you do that, then you can be sure that there won't be any antitrust issues that will arise. When you're looking to see what everyone else is doing, if you're looking at, like, you know, if you go to an association meeting and you want to have a discussion about commission rates, that's a no-no. Just because, remember, the FTC looks at trade associations and that they provide a valuable public service, in that they serve an industry, they provide, you know, they serve the interests of the public policy, but yet at the same time, the matter of fact is that this is, an association is a group of competitors. And therefore, you need to stay away from anything that can be construed or viewed as being any anti-competitive agreement or conspiracy.
So now, to be clear, can a company have a standard set commission rate?
Yeah, a company can have that standard. And what we would say is that with that, make sure that you have the documentation to explain why it is that that rate is being charged. You know, consult with an attorney and make sure that they don't see any sort of antitrust issues, and have copies of that documentation, like a memorandum. And then explain, this is why this commission rate makes sense for us to charge, and why we believe that this serves the clients, and at the same time, leave it open for negotiation.
Good. So are there any, I guess I still think of, in my daily practice, I still get people that'll say something, usually it's not while you're negotiating commission, but they'll just say, you know, how's the market? Well, blah, 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 blah. And they'll say, so what's the going commission rate nowadays? Is it still X? You know, and you're like, whoa, are you wearing a wire? But, you know, and I always tell our agents, just first of all, just say, look, first of all commissions are negotiable. You know, that's sure an antitrust. But, you know, it's easy to follow. You know, realtors are social, you know, beings. You know, we like to talk, and we like to interact and build relationships. So sometimes I think having that personality can kind of put us in a loose lip, sink ships type of environment. What do we say in those moments when we're with another person and they're asking questions like that? How defensive do we have to be? Because, you know, sometimes if you just put up your hands and say, oh, can't talk about commission, that looks kind of strange. Is there any dialogue that you would suggest to say to someone that asks that question?
Yeah, I mean, if you're involved in that type of discussion, I would encourage them to do their own research. You know, if they believe that that is the going rate, then, you know, say, hey, go look it up on Google and see what you think is fair, and we can have a discussion and have that negotiation. You know, not that, you know, those conversations are going to be the things that where, you know, someone is wearing a wire or the FBI is listening or anything like that. But I think it's just, it's good habit to be cautious about staying away and to veer away from those types of discussions. Because again, like I said, you know, all it takes is for someone to just say, I remember when Lamont was talking to other brokers and they were talking about commission rates. And then coincidentally, they all came up with the same commission rate. And then now that in itself can be a basis for an antitrust lawsuit.
Gotcha. Rodney, Rene, anything you'd like to add to the antitrust discussion? I know you're not lawyers.
I'm not a lawyer.
I know. I said you're not lawyers. So
Yeah.
Well,
Renee's a
Rene
lawyer.
actually is a lawyer.
Renee's actually a lawyer.
Oh,
I'm the only one who can get us in trouble here. So I'll be the one who speaks up. I would say that the other thing that you say, what do you do? Realtors, another characteristic of them, right? You guys aren't shy. So I can tell you wherever we're in a meeting and somebody starts talking about commissions and whether they're crossing that line or not, somebody in that meeting is going to say, wait, stop. We shouldn't be talking about this.
Right.
You know, and the other advice I would have, just listen to that little voice in your head. If there's some effort to try and establish an agreement related to commissions or to influence what others would do in commissions, you're likely crossing that line, but I wouldn't try to parse it. I would just be very cautious if you have conversations about commissions and try to avoid them.
Okay.
I would just add, you know, continue doing the great work of educating consumers, right, on both sides, on the buy side and on the sell side. You know, have that education, especially for first-time home buyers. They'll eventually likely become sellers. So, you know, giving them that insight into the market of how real estate works, how commissions are charged, who pays what. You know, as a buyer's agent, you know, I'm making commission from offered by the listing broker. You know, have those full-on transparent conversations, and you know, nothing will help the industry more than continuing the education of consumers. They're highly educated and they're adapting to the ever-changing role of real estate, especially in, you know, the technology-heavy side right now that we're having to rely on. But definitely have those conversations by way of education.
Antitrust. Go ahead, please.
Oh, sorry. I was just going to add, Rene brought up education, and I thought it's also good for brokers to get into the habit or make it a practice of reviewing an antitrust policy or do's and don'ts each year. And what that does is that, so then if you have licensees who may commit a bad act or deviate from that policy, you will have that defense to say that we go over the antitrust policy. They know that they weren't supposed to do this. And especially if they did that on their own, then you can insulate yourself.
So take commission out of it. What other areas does antitrust affect in real estate? Are there other areas, or is it just commission?
No, group boycotting, a blacklist, you know, I refuse, you get others to join you to work against a competitor or even against a service provider because you don't like the way that they do their business. You know, those are the things that can definitely come into play and raise antitrust issues. Anything that could be construed as being anti-competitive, you know, that does not serve the consumer's interest, you know, where the consumer loses out either in the quality of the product or that prices will go up or, you know, they have less options. All those things, you know, come into play with regards to antitrust.
What about if you know, we've had through the years, different models, business models for real estate companies, some that are fee for service or other types of models where they appear to charge less, but maybe their hourly rate is not less because they're doing less. They're doing things differently. Would it be an antitrust violation or an ethics violation for another realtor or another brokerage to talk negatively about an accepted real estate model?
Yeah, that could be if it's definitely pointed at, you know, a competitor within your market. And if you're just speaking just ambiguously or vaguely about something that's happening, like it's a nationwide trend, and that's not, you know, that can't be construed as being pointed towards someone in your marketplace, then that's probably okay. Still, maybe it's not the best to, you know, speak about a potential competitor in that way, but I think that's what you have to be careful about. I think the other thing is, you know, splitting of markets, or, you know, designating certain areas of the market that is going to be for, you know, one competitor and, you know, another one for another competitor. That can definitely raise antitrust. And then in terms of business models, I know that, you know, this has come up with associations, where an association will say, our members cannot engage in a certain type of business model because we think that this harms the public and that we think that it's not good for our membership. The antitrust has come down on associations like that. And they've said that whatever public policy basis that you're trying to use in order to allow that type of restriction did not pass muster. And they said that that is totally anti-competitive.
Got it. Gentlemen, we are getting to the end of our hour here. Any closing remarks you'd like to make or things you want our members to know about? Charlie, I'll start with you since your picture's up. Oh, now it's Rene.
No, thank you for the opportunity to join you all, and you know, appreciate continuing the discussion. We invite you to join us on the hub and also in the MLS Hour webinars that we do about once monthly. Any questions you have whatsoever regarding, you know, MLS or policy, feel free to reach out to our team, especially as it relates to maybe national insight. You might find that you know, things that we're seeing nationally are not too far different from what you're experiencing locally, and that informs the policy process as well. Just want to touch on one thing that we didn't address on the clear cooperation policy that I think is helpful for the current discussions in our country. One of the points that was heavily discussed and that was brought up in that review process of the policy, and also discussion at the MLS forum and the committee, is the fair housing impact and aspects of the clear cooperation policy. That's not new sight of, you know, what the MLS has done over the last 100 years, which is provide access to you know, full and complete and reliable listing information, not only to each other, to brokers and agents, you know, bringing them together. On the one hand, they're competitors, but they're also in a cooperative relationship, but more importantly to consumers. In this day and age, it's very easy for consumers to go online and you know, in a couple clicks, get access to listing information. Putting that listing information into the MLS, which in turn feeds the internet, and how consumers access information is important. Keeping listings off the MLS, creating pocket listings, or you know, practices that don't expose listings to the broader market could potentially have, you know, negative impacts on certain groups of folks, and we certainly don't want to go down that path. You know, let's promote you know, that access to listing information to buyers everywhere, not just those that are in the know of these pocket listings or limited exposure listings. With that, I'll turn over to Rodney or Charlie.
I'll go next. Just again, thank you very much. I think best advice, stay curious, right? And keep asking those questions, and where you need to, look to the Code of Ethics. It's a great tool that has served us. I think it was Lester who said it, 107 years, which is just so astounding to think of that. And there's concepts in the code that have been in there since the beginning, like arbitration and cooperation. So look to it, and if you need additional guidance or direction related to it, that's what Rene, Charlie, myself, our MLS team at NAR is there for. We're there to help you with in any way we can. So don't hesitate to give us a call.
Great.
Thank you, Lamont, for moderating this discussion. This was really wonderful. Great job by you. Thank you for Lester and Steve just inviting us and allowing us to talk to their members, our members. I really do enjoy this time. I believe in the value that our members provide to their clients. And I think like what Rene said, in terms of fair housing, getting people in homes, giving them that opportunity, I think is so important. And I just wanted to say that, we have a lot of information and resources on the NAR.Realtor website. And so kind of like what Rodney said in staying curious, there's a lot of information that's there that we look to update and continue to add. And as well, if you ever have to ask us any question, you can just reach out to us. Just call us or email us, and we'd be happy to talk to you.
Charlie, Rodney, Rene, thank you all for representing us so well, and stay safe and healthy. And with that, I'm going to turn it back to my friend Lester. Mr. President, back to you.
Again, I'll do the same thing that Lamont just did, Rodney and Charlie and Rene. It's important, especially during these times where we're not connected and able to see each other. It's really been important for us to be close to NAR. So we appreciate making yourself available for these type of conversations, and who knows when we might pick up the phone and call again. But it's certainly appreciated. This is extremely important information because, again, we talked about what the market is like, and then on top of what the market is like with COVID itself, we found ourselves having to operate different, using different tools. So the information that you brought on how we use that information and tools is extremely valuable. Again, thank you so much for spending time.